So good afternoon, everyone. We'll be starting in a moment. Let's hold on for a while so that a few more of our colleagues join in. Maybe we could go on YouTube the moment we begin. Yeah, so maybe let's give it about 5 minutes, then we proceed. Thank you.
Otherwise,
so good afternoon, everyone. We will get started. A few people are still joining, while others are joining us live on YouTube. So welcome to this exciting session today, where we are joined by one of our mentors for the day. And he is very prepared, very serious gentleman there. His name is Richard, who is a lawyer, and with a lot of interest in company and commercial law. And why did we invite him? He focuses a lot on startups, entrepreneurship development, fintechs. He will tell us what those ones are, and he will also tell us about the new media. He is also an agripreneur like many of us, and also quite seasoned in sales and marketing. Most importantly, he also writes. He's a columnist with the Business and Financial Times newspaper under the Start column, which demonstrates the intersection of law and business for sustainable business planning and management. So without much ado, colleagues, I will invite Richard to further explain the new media and the fintech that he works with, and then delve into the topic of law and startups. And most importantly, let's listen to him. Let's note any questions you have. We will have a session where we will have some questions and answers. Ask him any question. Richard, you are joining colleagues from Ghana and also from Nairobi, Kenya. Is this an exciting group where we share knowledge and knowledge transfer between our two countries? And all of us are in agribusiness. We are agripreneurs, and we are happy to listen to you. So, Richard, over to you. You can make your presentation. After that, we will interact. Thank you. Feel free to add anything that I have not introduced.
Okay, thank you very much, Amos, for the introduction. And good afternoon to everyone joining us from Ghana and Kenya. I'm delighted to be part of this presentation for today. It's a presentation that is in line with my practice focus as a lawyer. Like Amos said, I am largely involved with startups in helping them identify transactional pitfalls and to become regulatory compliance in their bid to grow and expand their businesses. And Amos did ask what new media and fintech is. So fintech basically is financial technology tools that are facilitating the use of mobile money technology for payments, for crowdfunding, for cryptocurrency, and other forms of new developments in the payment system ecosystem across Africa. So in Ghana, Bank of Ghana currently has regulations that regulates the processes for licenses for fintechs to operate. So as lawyers, we help those fintechs to meet the regulatory requirements of the Bank of Ghana through the assistance where we come up with policies that are required, governance structures and business models that support the regulatory requirement for the licenses. And in terms of new media, we'll reckon that technology is evolving very quickly. So every now and then, new forms of engaging and communications are coming up. So our focus as a tech company or a tech law firm as well, we have one of our practice group focus on tech. So we look at new ways of communication. Now we have Snapchat, we have TikTok, we have all forms of communication that are coming up every now and then with implications of privacy issues of the users and regulatory from governmental point of view. So we do that as well. That constitutes what we call new media. allowing us to look at new innovations as and when they come up within the entrepreneurial ecosystem in Africa. So without much ado, I will go to today's discussion. Today's discussion is primarily focused on legal documents that entrepreneurs and startups usually will be faced with or use in their day-to-day activities as business owners. So we'll be looking today primarily at those documents, what you need to note about the documents, what should be your approach to which of the documents to use at what particular time, so that you are legally protected to an extent as an entrepreneur in your day-to-day life. Because of your nature of business, we tend to focus more on how to grow the business, forgetting other issues that may crop up. And as we interface with service providers, with investors, with clients on a daily basis, we are not only seeking to derive benefits for our companies, but also we are creating legal problems one way or the other. So if you know what type of documents exist and what purposes they serve, you'll be able to know which of them to use at a particular time to be able to safeguard not only your interaction, but also the future of your business as an entrepreneur. So that is basically what we'll be focusing on today, to understanding what those documents are, what are the building blocks, and when you use them and when you do not need to use them. So without much ado, as lawyers always do, we are highly prohibited from advertising. So when we speak as lawyers on legal issues, we try as much as possible to inform our audience that the purposes of the communication or the engagement is not for solicitation or publicity of our practice areas, but basically for the purposes of training, as we will be doing today. So the purpose for today's presentation is not to advertise my service as a lawyer, but to help you understand and have basic knowledge about legal documents, as I've stated earlier. About myself, Amos covered a bit of almost all the issues that relates to me. I'm the managing partner for Sustainaris Attorneys. We are a group of lawyers focused on developing startups and entrepreneurial ecosystem. We work with founders to ensure that their regulatory compliance issues are addressed. As well, I am an agri-entrepreneur myself. So I have investment into agriculture and farming in Ghana. I've been sales and marketing practitioner for some years before becoming a lawyer. And I write extensively for the leading business and financial newspaper in Ghana called the BNFT. My column, the Start column, seeks to demonstrate how law impacts business operation and how managers and owners of businesses can take advantages of some of the opportunities that the law provides and able to grow and expand their business. And it's a monthly news column. It's also available online. So I have a website that uploads all the articles of this column for references for entrepreneurs who are interested in knowing more about what opportunities the law offer for their line of business. So without much ado, I want us to begin to think about these three categories of persons. So these three categories of persons are ordinarily persons we will interface with as agripreneurs or as entrepreneurs. So you may be dealing with a gentleman, let's assume he's called John, who has money and is interested in investing in your farming or agricultural technology. Or you may be dealing with a lady called Stella, who is not only a farmer, but also owns shops that sell farm-related products or provide services across your country. And then you may be dealing with Michael, who heads an innovation center in your country and is in a position to offer some support for your business to grow. The question is, in dealing with these people, how should you deal with them, or what kind of legal documentation should you execute with these people? You will not be able to execute the same type of legal document with these three different people. So the purpose of today's training is to help you understand that the nature of relationship will influence the type of legal document you will execute. So at the end of the session, we should be able to address this puzzle and be able to know what we will do with which of these stakeholders that we engage with as agripreneurs. So have that at the back of your mind. So at the end of the session, you should be able to address this puzzle. Now, is there any reasons or reason at all for legal documents? Why should we be concerned about legal documents? There are two basic reasons why we should be concerned as entrepreneurs with legal documents. Because generally, it is a law that provides for what is legal and what is illegal. The reason why cocaine, the trade in illegal drugs or illicit drugs, although lucrative, is not permitted is because the law says it's illegal. So whether you like it or not, legal documentation is very important because that will determine what you can do and what you cannot do. It is also in response to our nature as human beings, because as human beings on a daily basis in our engagement, we make promises and we are expected to keep those promises. And the nature of the promises we make is to the fact that we create obligations and benefits for the performance of those obligations. And we know that human beings as we are, sometimes there may be disputes. So if I promise to do A for B as benefits, and I do it and the other party does not perform his obligation, then it means there will be dispute as to what I get out of that performance of obligation. And then that dispute will need to be resolved. So the whole idea or the rationale for legal documentation is to provide a framework where parties will be able to address these general needs of law and legal documentation. So if generally that is the position, why should we be interested in legal documents as entrepreneurs? Ours is to have an idea, innovate around the idea, bring product or service, sell or provide a service for money. So why should we be concerned about legal documents? For what purpose? Why? Is it important? It is important because, like I said, entrepreneurs as we are, we always have ideas. And the essence of the legal document is to offer protection for that idea. That is why the law provides sometimes for IP right, intellectual property right. Because once you have an idea as an entrepreneur, that idea should be protected. And as entrepreneurs as well, we labor in the execution or in the implementation of our ideas. So the legal document will also provide protection for the reward and the benefits of our labor, so that people do not duplicate, copy, or imitate us and then begin to get the benefit of what we have thought as ideas and have labored for in bringing them as products and services. And like I also said earlier, entrepreneurs will also disagree. So when we disagree, we should also have a framework that protects us in seeking the resolution of those disputes. So in nutshell, no matter how you look at it as an entrepreneur, legal documents offer some kind of protection that you will need in your entrepreneurial journey, one which you cannot do without. So it becomes a basis for you being interested in understanding what the legal documents are and what they offer for you. So that is why you need to be interested in understanding the legal documents that we'll be talking about today as an entrepreneur. Now, what types of legal documents will you look at or be faced with, or you need to understand on your journey as an entrepreneur? There are basically three of them that we'll be looking at today. The first being the Memorandum of Understanding, the second being non-disclosure and confidentiality agreements, and the last being contracts an agreement. So we'll go straight into looking at memorandum of understanding. What does it entail? Memorandum of understanding, like the picture is showing, is just a meeting of the minds. The underlying principle is the fact that two people have decided on what to do. So the essential consideration is only the reflection of what the parties have agreed to do. And by so doing, it specifies what the parties, who the parties are, what they've agreed to do in terms of scope, what the roles and responsibilities will be, and what will be the nature by which that relationship will either be terminated or will expire by itself. Now, what it offers is that because it is non-binding, it is not one of the things that you can take and go to court and say you are seeking to enforce, and the court should give you a damage or award a cost because the other party had failed to comply with what you have agreed. It creates a starting point for further negotiation between the parties. So basically, it sets the conditions precedent for anything you want to do granular than the memorandum of understanding would have entailed. So for instance, you want to begin a discussion with another company as to how you explore your partnership, either in technical form or in monetary form, where they provide some service for you. Because you are not too clear as to what the nature of relationship will be, you seek to just sign a memorandum of understanding detailing what the parties will intend to do in the future. So that will not become binding if the other party does not carry on what the memorandum of understanding seeks to cover. However, it creates an opportunity for whosoever takes over from where you started off to understand certain things that have been agreed between the parties and how the negotiations in that respect can be advanced so that other things can flow from that. Now, if that is the nature of MOUs, that they are non-binding, they give the freedom for the parties to decide what they want to do in a non-binding fashion. What then should you be looking out for if you are, as an entrepreneur, seeking to execute a memorandum of understanding? Yes, it is non-binding, but like any other legal document, the capacity of the parties is important. So you must seek to clearly define what the capacity of the parties are. So for instance, if you are the owner of the company, you cannot have, for instance, your cleaner in your office signing a memorandum of understanding on behalf of the company, even though it's non-binding, because the cleaner does not have capacity to perform the obligations that will arise out of the memorandum of understanding. So it is important at all times to understand who is executing the memorandum of understanding on behalf of the parties. Roles and responsibilities must also clearly be drafted in plain language. Mostly what lawyers seek to do will be to make legal documents very robust and with a lot of legalese. Currently, lawyers are drifting from that because any document you draft for your client imposes obligations. So the parties themselves must be able at all times to read and understand. So plain language is being advocated for, plainly as possible. If Kofi is supposed to perform A, B, C, D, state it as clearly as possible. If there is any need for further negotiation, if there are any condition precedents or scope that must be followed in terms of advancing anything beyond the memorandum of understanding that you sign, that must also be clearly spelled out. And it's important, avoid the use of ambiguous words. You can not only be plain, but words that have multiple meanings, words that, depending on the context, the meaning will vary, or even within context, you could imply multiple meanings to them. You must seek to avoid them because they begin to be the starting point for any dispute. If I read and I don't understand, and you read, you have a different understanding, then we will never agree on what the word means or what the obligation is supposed to be. So as much as possible, you must avoid those unambiguous words that create problems for dispute creation. So that is about memorandum of understanding. What about non-disclosure agreements? Non-disclosure agreement. What is the rationale for non-disclosure agreement? The rationale is simply to say that why will a party be interested in signing a non-disclosure agreement? There are certain presumptions in law anytime a non-disclosure agreement is to be executed. The first presumption is that there is some information which is either protected or confidential, which the parties do not intend to disclose beyond the parties involved in the agreement. So because that information is not available publicly or is deemed to be confidential, we need to sign a non-disclosure agreement to protect that information from being disclosed beyond the parties that have signed it. And then it further acknowledges the need to make that information available. So as much as it is not an information the parties need to disclose beyond themselves, there is also the need to make that information available for a particular work for which the receiving party intends to use that information. And then the need to retain the right of the use of that information, especially the confidential nature of it, by the one who is disclosing it. So if it relates to your financial information, showing whether the business is doing well or otherwise, unless you are a public company, the law does not demand of you to make public your financial statements. So you can keep it as private and confidential as much as possible, except when you file with the Registrar General in your annual returns. So that information, you retain the right of the confidentiality in that information. So as much as possible, even where you sign non-disclosure agreement and then proceed to disclose your financial information to the receiving party, it doesn't mean that you've lost the right in that confidentiality of that information that you disclose to the receiving party. You still retain that right, and you still have a right, unless used in line with what the use is permitted for under the agreement that you sign. Now, so if that is the essence and the reason for why you do that, what should then be in a non-disclosure agreement? If you are signing a non-disclosure agreement, what must that agreement cover? Each of these issues are as important as the other. There is no priority for any of them. At all times, a non-disclosure agreement must indicate who the disclosing party is and who the receiving party is, because someone must have the information and someone must be in need of that information. It must also indicate the subject matter that the disclosure relates to. So if you are disclosing the information for the purposes of maybe getting financial assistance or investment in your business, that subject matter must clearly be stated. The importance of stating the subject matter is that where the information is used beyond the subject matter, then we can make a determination of whether there is a breach or otherwise of the non-disclosure agreement. So where you leave the subject matter blank, or you make a blanket statement in respect of the subject matter, then you are seeking to allow the information to be used in whatever context the receiving party deems or want to use it. So to prevent that, you must indicate the subject matter for which the information can be used, so that as much as possible, it is used only within that context. Now, you must also state that the information you are disclosing, what of that information is confidential? Because it is not always the case that everything about your company will be confidential. It is never the case. There are certain things about your company that are public. For instance, your product, except for the formula you use or the ingredients you use and how you mix them in what quantities to arrive at your product, everything else about your product is public, because somebody can go to the shelf in a supermarket and pick your product. So your brand name, your ingredient composition may all be public. However, there are certain things which is confidential in that respect. Maybe what quantity of ingredient A you miss to be able to get your product in the right taste and in the right smell or in the right whatever. That is which is confidential. So you must restrict what you describe as confidential and then use it in the non-disclosure agreement. So the party who is receiving the information knows specifically what is confidential. And then you must impose an obligation on the party to keep and maintain the confidentiality of that information. And sometimes how we do that is to ensure that even where they go beyond the confidentiality nature of the agreement and are intending to disclose it to other parties that work on the related subject matter, they may come for consent from you before they disclose it to them. So for instance, an investor will work with an accountant or a financial analyst in understanding whether your financial models and your finances are sound for his investment. So even though you sign a non-disclosure agreement with the investor, he may give the information you provide in respect of your financial statement to a financial analyst. That is beyond him who is the receiving party. So you must provide the context within which the disclosure is either restricted and whether there is a need for prior consent to be sought from you in any instances where the disclosure will go beyond the one who had received and executed the non-disclosure agreement. So these things must always be provided for in the non-disclosure agreement. So that is essentially what non-disclosure agreements also cover. Now, what then are contracts and agreement? We hear these words very often. Are there any distinction between contracts and agreement? Yes, there are some distinctions between contracts and agreements. Agreement generally represents mutual understanding between parties with an indication of rights and responsibilities. And generally, agreements are not enforceable. That is why it is not every agreement that is a contract. So if you agree with your father that he will pay you $200 every month for deciding to become the first entrepreneur of your family, that you cannot seek to enforce it. If your father fails to pay you $200 at the end of every month, you cannot be on your way to court, or you cannot get a lawyer to write to your father to redeem his promise, even though you have an agreement signed. Because the nature of that is just to represent an understanding between you and your father. But for some types of agreement like that to qualify as a contract and become legally enforceable, there are certain building blocks that we'll look at very soon. It is only because they were done on a binding obligation involving terms and conditions. So very soon we'll look at what will make one a contract and what that does to generally agreements as we will know in our various or respective countries. So essentially, all contracts are agreements, but not all agreements are contracts. Why so? Because for an agreement to be called a contract, there are certain building blocks, or there are certain boxes that you must tick to say that then this agreement becomes a contract. And generally, these building blocks are 5. The first being the fact that there must be an offer. There must be an offer, and that offer must demonstrate a clear promise of the willingness of the parties to do a particular thing or activity with terms and cost allocated to it. And that specific offer must be accepted. Now, the dynamics or the difficulty mostly is that when you make an offer, for instance, you are a farmer, you farm maize, and then you have a buyer in the city center that comes to you and say, I want to buy your maize bags, 100 kilos for $100. And then you say, okay, I will give you 50 bags for $120. Your 50 bags for $120 is not an acceptance of the offer made by the buyer from the city center, because the buyer was clear as to what he wanted. He wanted 100 bags for $100. So anytime we say an offer has been accepted, it is a confirmation of the exact offer that has been made. Where you vary that offer made earlier by the city center purchaser, you will be deemed to be making a counter offer, which then now means that the city center buyer must now be the one making an acceptance of that offer. So whatever the offer will be must be accepted in the same manner in which it was made. It is also important to check for capacity, because in law, the existence of a legal right, or whether you can enforce that legal right, is conditional on the capacity of the parties. So if you are not the farmer, however, is one of your workers who had agreed with the city center buyer to sell maize to the city center buyer 100 bags at $100, can the city center buyer enforce that against your company? No, it will be difficult. Even though there may be exceptions in law that technically we will look at if a fact pattern like that arises. However, on the face of it, your worker does not have capacity to bind you or the company to that offer, because he or she will not have the legal right or the permission in law to engage in such activity. However, generally in law, the capacity issues could also be from the angle of age. And depending on the jurisdiction in which you find yourself, the legal age generally is either 18 or 21. So if you engage the services or you make an offer, an acceptance, or a contract with someone who is not of that age, unless for exceptions in law relating to necessities, we will say the person does not have capacity in law to contract. So capacity is very key in understanding whether the agreement that the parties have signed is either a contract or a mere agreement. The other issue we will look at is the issue of consideration relating to the promise to pay a certain price for the promise for a certain obligation. So like the example I've been given, the 100 bags of maize was supposed to be bought at a certain price, $100. So that $100 price is deemed to be the consideration for the offer of buying the 100 bags of maize. And then there must clearly be the intention to create legal relation. That is why the first or the earlier example I gave of your father and you agreeing to undertake a certain obligation as an entrepreneur, the first one from your family, and be rewarded a certain amount of money at the end of every month, cannot be taken to court, because it is in the nature of family or social promises. And the intention by your father in agreeing that with you was never and cannot be that he intended to create a legal relation, which will give you right to go to court if you fail to honor that promise. It would have been intended for the purposes of the family or social status or relationship that exists between you and your father. So in contrast situation, at all times, we look to the intention of the parties. Were the parties making the offer and the acceptance of the promise, if they had capacity and consideration was present, did they intend to create legal relation? And for you as a business and as an entrepreneur, a farmer, cultivating maize, when your maize is ready and you intend to sell it, you will not be intending to be doing it on issues of family and social status. You are a business, you've been incorporated to run as a business. You have a legal identity. You would have been doing so for the purposes of fulfilling that legal purpose for which your firm or your business has been established. So the relationship and the intentions thereof will be one of seeking to create legal relation. So when all these 5 building blocks are available in a certain agreement condition, then we quickly can decide or say that the parties have executed a contract, and then it becomes enforceable You can go to court, or you can use any of the available dispute resolution mechanisms to seek redress where there are breaches. But what then do you pay attention to if you want to contract because he has a legal or enforceable character? These things you must consider, which are very key. The first key things you must consider is the term. And generally, the terms are the key ingredients for the formation of a contract, the failure of which will result in a breach, and will entitle the one who suffered the breach to a remedy. So, for instance, you wanted to buy maize 100 kilos. If the farmer decides to bag the maize 20 kilos each, or you have agreed that you are buying 100 kilos, it should be supplied 31st or 30th day of every month. If the farmer supplies the next month 15th, you can decide not to take it. The farmer will be deemed to have breached that contract, because a term which is critical for the fulfillment of that contract is that the 100 kilos of maize should be supplied at a particular time. Maybe because you also uses it for any other purpose you use it for. So if the farmer fails to meet that, then the farmer will be deemed to have breached the term of the contract. However, it is not every detail of the contract that will be a term, because all are not as crucial as others are. So the crucial element for which the other party will be deemed to have failed to supply will be deemed to be terms. And then there are other things of the contract that you must also pay attention to, which we call conditions, events upon which the contract hinges. So for instance, in your practice as a farmer, when you sign the contract to supply 100 bags of maize, the one who was buying told you that it is conditioned on the fact that he is able to set up a maize grit factory in Accra. If he fails to set up the maize grit factory, it means you cannot be supplying him 100 kilos of maize every week. Because for him to be able to pick your 100 kilos of maize every week, he needed to put in place the maize grit factory. So the maize grit factory becomes a condition upon which the contract hinges. And there are several examples of that depending on the nature of contract you are signing, that there are certain things on which the contract hinges. So if those things are non-existent, you do not have a contract. And then we will have warranties sometimes as part of contract. However, the breach of a warrant does not mean that the contract cannot proceed. So for instance, the maize is supposed to be 100 bags, 100 kilos per bag. If you bag it 50 kilos each, yes, even though you've not fulfilled the term that says that it should be 100 kilos, or the maize was supposed to be without aflatoxin or death, or it should be at a certain percentage, usually it's 12.5, whatever the dryness is. If you do not achieve that, the parties can agree that yes, you've not achieved that, but it is of a lesser effect than of a term failure to supply at the particular date. You have supplied at that date, but the conditions under which you were supposed to supply, you did not meet them. So you will give warrants, or you are acknowledging that the maize you will supply will be of a certain quality. If those qualities are not attained, you will have the opportunity to remedy the situation so that the contract can continue. So these are some of the things that you must pay attention to as an entrepreneur when you are executing a contract. And then mostly, before you enter into a contract circumstances, or you engage or you execute any contract, there are things you must also do apart from the things you will have to pay attention to. Because contracting is like a game. And for footballers and for coaches, before they go onto the field and play, you must understand your opponent. You must also know yourself. so that you'll be able to use what you know of yourself and know of your opponent to negotiate a favorable term. Because if you do not know yourself and know your opponent through due diligence, you will not be able to offer or negotiate a favorable term. Because sometimes an investor comes and says and makes an offer and say, I want 10% of your company, and I'll give you $50,000 for that 10%. If you do not know what your company is worth, you may accept that $50,000 for 10%. But if you know what your company is worth, because you have engaged an accountant or you have engaged a financial analyst to do the financial models for you, and you know that your company is worth this amount of money or X amount of money, you will be able to say that, look, yes, I like your offer, $50,000 for 10%. However, this is the worth of this company. The minimum I can take for 10% is not $50,000, it's $100,000 because of this, that, and that. So if you know your strength and know who you are negotiating with, you will be able to use it to your advantage. And mostly, it is the experts that are able to help you in knowing yourself. So if it means seeking the help of experts, you need to do so that you are well grounded. You know, you speak to facts, you speak to figures that will help you in negotiating a favorable contract term. And when you are done negotiating and signing a contract, usually we go to sleep, but that is where the work begins. So you cannot go to sleep once a contract is signed and performance is and the parties are happy. You must remember that every time a contract is signed, in that contract are certain obligations that you must perform for a reward, or there are penalties when you fail to perform the obligation. So the first thing you do quickly is to do a checklist of all your obligations under the contract, and then begin to track whether you are performing in accordance with those obligations that you've signed on to. Because if you do not, then you will be liable for a breach. And however, when you do as well, then you'll be entitled for a reward. So do not just execute contracts, dash them onto your tables and go to sleep. No, you need to do a checklist of all your obligations under the contract and begin to track performance, not only for yourself, but for the other party, because you should be in a position to tell the other party that you are also not performing your obligation, or you are delayed on this obligation, remedy it. And where there are breaches, because you are business people, you need to talk first. That is why most contracts will have dispute resolution provisions as to how the parties will resolve dispute. Yes, use those methods first, but always communicate with the other party who is breaching. And then if it becomes necessary, then you go seek the help of a lawyer to see how legally you can have some redress for a breach that you've communicated on and that has not been remedied. Now, the biggest challenge now, and what most entrepreneurs face, I also face the same challenge, is how to access lawyers, because lawyers do not come cheap. So we seek to now rely on online resources. So is it advisable? Yes, technology is making our life easier day by day. So now almost everything is available online, either for free or at a fee. But like I said, these legal documents have specific implications. So if you are not drafting it yourself and you are adapting, you must be very careful what you are adapting, because legal words have legal meanings, known to lawyers, conversant for practitioners. So if you're not careful, you think that, oh, this word is just English, or you understand it. So let me just put it or leave it from the template you found online. Just let me leave it. It doesn't mean anything. It could mean something else in the agreement. So as much as possible that we are making use of online resources, we must also be careful about how we adapt those legal documents to our circumstances. And I'll always advise that even where you adapt, you still can show it to a lawyer to just read through for you to see if everything is okay before you sign. If not, you may potentially be signing your death warrant without knowing, and then you end your business earlier than you should have. So that is very key. Now to the puzzle we started with. John, the financier, Stella, the shop owner and the farmer, Michael, the head of an innovation center. I am sure by now, given the kind of relationship you have with these people, we'll all now be reckoning what type of legal documents that we need to sign or execute with these type of persons or these stakeholders. And John, definitely being a financier, the first thing you have to do even before you disclose your financial documents will be to sign a non-disclosure agreement, so that when you disclose your financial documents or you disclose your business DNAs and everything that relates to your business to him, he doesn't use it to your disadvantage. And when he's interested in executing or supporting your business, then you can look at signing a contract that details what he will perform and what becomes legally binding between the two parties. For Stella, who is just a farmer and a shop owner, you are not going to disclose anything of your business to him or her, because the relationship you have is one of selling your finished product, the information for which is also available publicly. So you don't have to disclose anything to Stella for you to be signing a non-disclosure agreement with Stella. You are just supplying Stella produce from your farm, or you are providing services for Stella. So that can just be a straightforward agreement, unless, of course, there is some information which you think is confidential that you have to share with Stella. There will not be any need to sign a non-disclosure agreement with Stella. And for Michael as well, because of where he sits and providing support which are non-binding on him, you know that then your relationship with Michael will be underpinned by an MOU. Because if Michael fails to provide the training he has promised to provide you, we cannot be on our way to court to say that he said he's going to provide training twice a week. He's just done once a week. So let's go to court for the court to compel him to honor the twice a week training. You can't do that. No court will listen to you. So for Michael, the best you can do with Michael is a memorandum of understanding, expressing the understanding between the parties, so that potentially, even when Michael is not the head of the center, new heads of the center will have a precedence or an understanding of the history of your relationship with Michael. And then you can negotiate anything you want to negotiate with the center in terms of support going forward. So that will help you in knowing what you sign with each other. So on that note, I've come to the end of my presentation. I thank you so much for listening to very long, boring legal talk. I hope it was useful. For those who want to further their understanding of the issues I cover on monthly basis, like I said, I have the start column. It's available online and in print. You can follow our pages on Facebook, Instagram, and LinkedIn, and then we connect from there. Thank you so much. I await your questions.
Thank you. Thank you. And I'm sure everyone can understand why we found Richard to be the best to be able to facilitate this. I think it's been very informative. So I can see Daniel's hand is up. So I think I will want Daniel to go ahead before I make my further observations. Daniel, go ahead.
Okay, thank you, Lawyer Richard, for the presentation. It wasn't boring. I enjoyed it so much because over the years, I have encountered a lot of legal issues. Farmers, you assist farmers to get access to funding. Then the legal issues in the document, they forget. and later they will be pleading. So my question is, I got money for one farmer groups and pest and disease control organization, but I didn't sign MOU. Now the person doesn't want to give me my 10%. So is that something that I can do to get the money, or because I didn't sign MOU, I should leave it? Thank you.
Okay, thank you very much, Daniel, and thanks for the feedback. On the question you've asked, it is not even an MOU that you should have signed with such a person, because the intention is clear. You were going to work for the person, and the kind of work you were going to do for the person in terms of sourcing for financing, you needed to be rewarded. And where you are rewarded, where you are not rewarded, you are entitled to it legally. So because of the underlying entitlement you have for the work you've done, there should have been a contract leading to the rendering of your service. And the nature of contracts are such that it could be written, it could be oral. So if there was this understanding at the beginning that you were going to perform so and so services for a so and so reward, and you have complied with that and done that performance, even though there is no written agreement, I think you can still enforce that by seeking to get your benefit for what you have done.
Okay.
Thank you.
So, sir, how am I going to do that? Because I got him a grant of 40,000 euros, and he's supposed to give me verbally. I didn't record him, but we discussed that I will take 10%.
Okay, so that you can get the services of a lawyer to write to him.
But now he's saying that he will not pay. I can take him to court.
Yeah, maybe he's calling your bluff. But if there is that agreement for the services you've performed, then like I said, you are entitled to your reward. That you can engage a lawyer to pursue for you.
Okay. Thank you.
Welcome.
Thank you. Richard, I have a quick question for you. And the question, many of our entrepreneurs here do deals online. So they are on their Facebook pages, Instagrams, and all that. Then all of a sudden, someone sees that you have this interesting, or you have got this product and all that. Then someone makes orders online. A delivery is effected, but the payment is never made. Was there a contract there? Would you please elaborate to our entrepreneurs the kind of laws, because they do a lot of work online? Would you elaborate the kind of laws that would guide those kind of relationships? Thank you.
Okay. Now, the e-commerce space is a very tricky one. Yes, it could amount to a contract circumstance, but because of the nature of how fraudsters and other cyber theft is being engineered using the e-commerce space, entrepreneurs may need to be careful in dealing with those unidentified persons, because at the time that you are doing the transaction, the person is hiding under a username online. So the true identity of that person is not known. For you to say that you can now go and sue or chase that person for the payment for the goods and services you provided. So in most circumstances, what service providers do online is to demand payment before deliveries or delivery on payment. So you use your own delivery services, and when the delivery is being handed over, there is payment before the delivery. So at every point in time within the distribution channel, you have control over the goods until you receive payment for it. If not, it will be a quite difficult case to pursue, because most people online are not using their real names and identities. So we as entrepreneurs must employ the extra skills in becoming careful in dealing with people online.
Thank you. Yes. That's very well answered. That you've got to be very careful about, especially identity, and possibly also you can emphasize or say something about identity fraud in the context of the online programs, because we are interacting with people online, and identity fraud is on all the time.
Yes, very true. Very true. Thank you.
So maybe I'll pass over to Frederick. And Richard, everyone is saying that it is very informative. Wycliffe is saying very insightful. Thanks, Lawyer Richard. Kertich from Kenya is saying very educative presentation. Thanks, Lawyer Richard. So before before I get to Fred, Daniel, you want to say something again? And indeed, anyone who wants to ask a question can simply raise hand. I will allow. Thank you.
Yeah. So, Lawyer Richard, my question is, now everybody is adjusting to see how they can help startups. So as lawyers, we know it's expensive to contact you. So are you adjusting yourself in terms of the cost you charge to help SMEs approach you? And can we get lawyers on part-time basis or contact them when it is necessary?
Okay, that's very true. Cost of legal services is quite high. So for some of us, the advantage we have, like I said, we are entrepreneurs ourselves, and the difficulties you face as an entrepreneur were ones we face as well. So coming into the legal profession, we have a clear understanding of what the pricing should be for businesses that we are supporting to grow. So we do not apply a blanket pricing structure. So depending on the business need, we are open to have a discussion on what pricing is good for that business and is sustainable. Because if the business is not able or spends all their money to pay legal fees, then you're also not helping the business to grow. So at every point in time, the business need is important for us in agreeing what we charge as lawyers. And it could be done in ways such as maintaining us on retainers, where you pay certain amounts depending on your needs on monthly basis, so that anytime within the month you have a legal problem, even though sometimes we establish thresholds for what the legal problem should be, you can call on us and we are available to assist you resolve that legal problem. So those are some of the things we do. So we do not just have a blanket pricing structure.
Thank you, Richard. Another question that has come in is regarding the usage of, for example, you are in Ghana and you have this, you have your production line, and then someone comes, a new person comes into the market, most likely a competitor, distorts your name or symbols, and then starts marketing their products. Maybe you can also offer some legal, some bit of advice on what an entrepreneur can do in such circumstances. Here you have your product, someone comes, maybe your product is labeled Richard, he comes and changes the Richard a bit, but it's still looking like Richard. Yeah, and then before consumers know it, you have lost a bit of sales.
Okay. Now, before you have protection for your idea, you remember one of the slides was on the fact that the law offers protection for your idea. But the law also recognizes that people may think alike. So whilst you sit in your house or you are in a different part of the country having a certain idea, somebody else by coincidence may be at a different part having the same idea. So usually what the law demands of you is that once you have the idea, you have a product or you have a service flowing from that idea, register the idea. That is why we have IP rights, where either it's a trademark or it's a patent or it's copyright, whatever form it is, you must begin to register it. When you register those ideas in any of these formats, it offers you legal protection against anyone who seeks to pay off your hard work. So if somebody tomorrow comes into the market and is either using a name which is very similar to your name, or is selling a product which has the same taste or the same formulation as yours as a result of copying what you have been able to develop, because of the registration you have for your idea, you are better off in seeking legal remedy for your effort. Because in court, it usually becomes a question of who was the one who had protection for his idea, or how do we determine who even started the business first? So I always encourage entrepreneurs as much as possible to spend some effort to begin to register their ideas, to begin to provide legal protection for the ideas, either by use of patents, by use of trademark, copyright, whatever form that your idea is. Let's put some legal protection around it so that when people begin to copy or pass off your product, legally you will have a right to take them on, and then you're rewarded for your effort.
Thank you very much for that. So maybe I will open up any other question. Whoever has a question, please just raise your hand and allow you to ask. Daniel again, go on.
Yeah.
It's okay. It's okay, Daniel.
Yeah, okay. Please, sir, when you sign a contract with farmers who are illiterate, is it your responsibility to train them to understand what you want? Because sometimes you go back and they tell you, we forgot of the quality. We forgot that we have to pay you this. We forgot. So is it your responsibility to go to the other side to build their capacity on what you want, because they are lacking in terms of education? Thank you.
Okay, thank you. Your responsibility is first and foremost to ensure that they understand clearly before even signing. Because without that understanding, contracts is the meeting of the minds. So if the other party doesn't understand what the obligation is, then what did they sign in the first place? So you must do a lot of work before the execution of the contract by making sure that everybody understands their obligation and consents to the performance of those obligations. So that when you sign the contract, it becomes easier for them to perform. But as an add-on to that, you can also do a checklist for them. Once they sign the contract, you must do a checklist for them that specifies the obligation they are performing and the timelines within which they perform the obligation, so that at least they keep up with what they have agreed to do under the contract.
Okay. Thank you.
Okay, thank you very much for that. That was Daniel Owusu. Daniel Ado, please go ahead. It's your turn.
Okay, thank you very much, Richard. My question would have probably be a follow-up of what Daniel Owusu had already asked. The first one is, so for instance, you are a farmer and then you want to lease or rent a land somewhere. Now you get there and then these people are not familiar with these agreements, contracts, and so on and so forth. So, you know, for leasing a land to most of a period of years, and so I think it's best that you get some agreement or contracts with them. Now, you would, with the understanding or your level of, say, understanding to some of these things, you suggest that you get.
Hello, Mr. Ado, your line is breaking.
Oh, sorry, sir. So my question is that, so as a follow-up to Daniel's question, for instance, you get to lease a land and then you get to a village where you want to lease, and these people are not familiar with agreement and contracts and all that. And so most of it tends to be and oral sort of agreements. Now, for instance, you get into business, you start, and over a few years, a different person from probably the family that get the land also comes in, and it's like, this is not the right person who was supposed to say lease the land out and so on and so forth. And now, because there were no written or documented agreements, what can you do to help address some of these issues? And then my second question will be on as a startup or an entrepreneur, agripreneur, and then you want to register a business, from your own experiences, what form of registration would you advise? Say a sole proprietorship, or going into a partnership, or probably doing a limited liability? Thank you.
Okay, thank you very much, Mr. Ado. Now, to your first question, from my own experience in land acquisition, because of the long-term nature of some of these acquisitions, and also because of the problems we have with our land tenure system, usually what I advise is that when you are in the process of acquiring land, you must do an extensive work in terms of engagement to understand the true owners of the land. Because without that extensive work, you be paying money or engaging someone who may not be the true owner of the land. And then the true owners will come up along the way and begin to create problems for you. So first of all, you must be extensive, you must be elaborate in your search of getting to know who the true owners of the land are. And then also, you must also do some work in terms of how you pay for the land. And my advice is that today is an old man who is the head of family. In 10 years, 5 years from now, he may be dead and gone. So if you pay for land for 50 years and you give all the money to the old man, when he's gone, the new head of family will trouble you. So even though you are agreeing for 50 years, your payment can be every 5 years or every 10 years. So at every particular time, somebody who is then the head of family is assured of some income from your use of the land so that you can have peace on the land. So you need to look at how you schedule your payment as well, because what brings the problem is where people begin to feel that somebody has taken money and they are not going to benefit from the land. They will give you problems. So you need to work on that. Then to your second question, business form. As an entrepreneur, we take risk. Sometimes we convince ourselves that the risk we are taking is measured and that we have control over the risk. But the dynamics of business operation is such that you cannot be too sure of where the risk may take you. That is why in law, there are forms of businesses that provide protection for your personal liabilities. So to the extent that we are risk takers, and we are also not soothsayers to be able to determine the extent of how the risk we have undertaken to take will take us, I always advise that entrepreneurs should incorporate a limited liability company. So to a large extent, you are not intending that you will not run your business properly. But where difficulties arise and then liabilities become the order of the day, personally, you will not suffer any issue or any liability, because then the liabilities of the company are limited to the assets of the company. So as much as possible, understand what you are taking on, because if you register a sole proprietorship or you register as a partner or a partnership, the liabilities are personal. So it is not only the business that will go down, it goes down and goes down with you. So personally, you will be chased or you will become liable for the death of the business. But if it's a limited liability company, except in limited circumstances where it's demonstrated that you have defrauded people or you've acted in manner not consistent with good faith, the liability is limited to the business. So you can have some breathing space for the risk you have undertaken to provide for a better world.
Okay, I understand it, and then thank you very much, sir.
You're welcome.
Thank you for the precise explanations and also picking a question that I had. I actually wanted to ask about the issue of registering as an individual, the issue of registering as an individual. I also have Monica. Do you want to ask your question now? Monica has a question that touches on intellectual property. Are you there, Monica? I'm sorry, Monica, we can't hear you. Okay, but Monica nevertheless says that it's an insightful session. That's okay. So any other question? Daniel, is your hand still up or we need to lower it now?
Prof, this is another Daniel.
Okay. So you have something to say, you can go ahead.
Yes, I want to thank Mr. Richard for the nice session today. I also have one question for him.
Please go ahead.
Okay. So mine is a conflict between myself and my partner. We registered for a limited liability company and in Ghana here. And the challenge is that we started with an agreement, like you said, but that one was verbal, even though we were still drafting a founders agreement between the two of us. So once we agreed verbally that we were going to sign a founders agreement and we needed to get the company incorporated, instead of signing the mistake we made was that we did the incorporation before signing the founders agreement. So now we are going into business because now is our season. There were some commitments he's supposed to make now. And now he's trying to twist my arm by demanding for a share percentage that is different from the shareholders agreement that we drafted. He has a copy of the shareholder agreement, but hasn't signed it yet. But according to Registrars General's Department, during the registration, he already owns 30%. But he's now asking for a higher percentage, which I'm not willing to cede to him. And my question now is there a way we can reverse his ownership since the idea is generally mine and he only availed himself for the registration process?
Thank you, Daniel. That is a very tough one because there is usually the presumption of ownership on the basis of the registration at the Registrar General's Department. So whosoever is listed as a shareholder is deemed in law to be a shareholder properly so called. Unless you can demonstrate otherwise, like you have narrated, that the purposes for which his name appeared on the registration document was just to hold the shares in trust for you. It is only under such circumstance that his name can be removed or his shares transferred to you as the 100% shareholder. If not, it will be highly difficult because your registration document lists him as a shareholder. So it's an issue we can have a discussion on.
Yes.
And then see how we can help. But we need a lot of evidence to be able to demonstrate that he was just signed on to hold the shares in trust for you and that he's not a shareholder properly so called, even though his name appears on the document as a shareholder.
So he was supposed to be a shareholder on condition that he provided certain contributions, which he has not.
Okay, so if he has been giving shares in lieu of certain contributions and he's not, then what you can do will be to go through the forfeiture process. So by the forfeiture process is where you now make a demand on him officially to pay for the contribution he has promised for the shares he has in the company, or forfeit the shares. So if he fails to pay, and then he forfeits the shares that he has in the company. So he is assumed to be currently a shareholder who has unpaid shares. So until he pays the contribution he has promised, he is then not entitled to the benefit of the shares. So you can use the forfeiture process to get him to lose the shares that he has. But you must first serve him notice to redeem the contribution he has promised to do, and when he fails, before he is able to forfeit the shares.
Okay, thank you.
Thank you very much, Richard. I see we are having very good reviews online, and people are saying they are really benefiting from your work. Now, if this is what you call boring, what is boring? I would want to attend your best session if this is boring. Yeah, but there's another question. I don't think this is on law specifically, on a legal issue, but I think it's much more of how we behave as entrepreneurs. And someone is asking, according to your experience, why is it that SMEs take legal issues for granted?
Two things. One is a lack of understanding of legal implications for the decisions we make. And mostly we think that because we are entrepreneurs, ours is just to pursue the business ideas we have, and that it has no implication legally. So that lack of understanding pushes us to only focus on the ideas we have and just be working towards the implementation and the fulfillment of those ideas. And then we forget that there are legal issues to deal with. And it's not only legal issues, there will be HR issues, there will be accounting issues, there will be tax implications and all that we forget about as entrepreneurs. So the lack of information and understanding is one. The other is also the issue of cost. There is that perception that lawyers are not cheap. They don't come affordable. So if I will pay a lawyer maybe 10,000 cedis or $1,000 for day service, let me take the risk and do it myself. But doing it yourself may also not be the right way to resolving that potential problem that you will have. So entrepreneurs must begin to now have a conversation with law firms and lawyers as to how they can tailor-make services for their needs. And I'm sure I provided some insight earlier that depending on your need, we as a firm, we look at how we can provide services at an affordable price and then be able to help you grow. Because we understand that tomorrow's businesses, the blue chip companies we see today, are the businesses we have today that need support to grow. So it's a conversation we can have. It's a conversation you should have with any lawyer to understand where you are currently and what the person can do for you, so that at least the legal headaches can be a thing of the past, so that you can focus on your work as an entrepreneur.
Thank you very much for that. Richard, it's been very exciting to have you on board. You've shared very important insights. First of all, awakening us to why it's important to have legal documentation, taking us through issues of intellectual property rights, taking us through issues of non-disclosure agreements, as well as how to go about contract. So we thank you very much for honoring our invitation, and this has gone on very well. We've seen lots of comments, and to our entrepreneurs, we also thank you for attending and engaging our mentor for the day. He's done a great job. So with that, we'll come to the end of the official sessions. I can see Dorothy is saying, I really loved the session today. So with that, we come to the end of the session for now. And I will close it unless if my colleagues, Fred or Mo, has any final parting shot before we move over, or before we close the session.
Right, Prof. Thanks so much for the moderation, and Richard has done some good justice to the topic at hand. we believe that, I mean, you've said it. I just want to reiterate that entrepreneurs have some information to work with as they surge on the journey of entrepreneurship. So we're always here for you, the entrepreneurs. If you need a bit of clarification around these issues, don't hesitate to reach out to us. Thank you very much. And thank you, Richard, once again.
Thank you so much for having me. And I wish everyone all the very best in your entrepreneurial journey.
Thank you.
Thank you.
So anything from your side, or we still have a minute, so.
No, thank you very much. Interesting conversation, and there's a lot of engagement from the agripreneurs, which was really good. Thank you very much for your time.
Okay, thank you everyone, and enjoy your weekend. All the best.
All the best.
You can leave the meeting at your pleasure.